confinement, and the second is that the trial court erred by imposing a consecutive sentence. Regarding the first issue, manner of service, the threshold question is whether Mr. Murray was eligible for community corrections under TCA section 4036-106C, the special needs exception. There is a long line of opinions dating back to 1989 with State v. Staten, holding that to be eligible for community corrections under the special needs exception, that a defendant must be eligible for probation under 4035-303A. These cases are wrongly decided and should be overturned. 4036-106C provides felony offenders not otherwise eligible under subsection A and who would usually be considered unfit for probation due to histories of chronic alcohol or drug abuse or mental health problems, but whose special needs are treatable and could be served best in the community rather than a correctional institution, may be considered eligible for punishment in the community under the provisions of this chapter. In Staten, the court held that in order to be eligible for community corrections under subsection C, a defendant has to be eligible for probation. And the court's rationale was, quote, that the waiver of fitness for probation is meaningless unless the normal statutory criteria for probation apply to subsection C participants. And I would argue that this is an extremely strained, counterintuitive interpretation of the statutory language that's made over the courses of about 3 sentences of analysis in that original opinion. And for the last 34 years, this court has asserted this rule over and over again in, I think, maybe dozens of opinions with no additional analysis or justification. I think the central problem with the Staten rule is that it violates basic principles of statutory construction. The most fundamental rule of statutory construction is that courts must apply the plain meaning of a statute's text without any kind of forced construction that unduly broadens or narrows the scope of the law. Subsection C makes no reference to the limits on probation eligibility set out in 4035-303A. Now, at the time that the Community Corrections Act was passed in 1985, the operative sentencing law was the Sentencing Reform Act of 1982. We didn't have 303A quite as we do now in its current form, but its predecessor statute, in effect at that time, is very similar in that it sets out certain offenses that are not probation eligible and a maximum sentence length for probated sentences, which at that time was 8 years.
But you had the same problem the case before you had, do you not? The Supreme Court has said that this is the standard. In Grindstaff, the Supreme Court has said that. So do you not have the same issue in that there's not much we can do at this point? You have to take it up with someone above us.
Respectfully, I think that is overstating what the Supreme Court did in Grindstaff. Grindstaff was a post-conviction case dealing with an attorney who had pled his client with telling him that he was eligible for community corrections at a subsequent sentencing hearing. The Tennessee Supreme Court held that that lawyer was ineffective in large part on the grounds that there was this body of case law out of this court saying that defendants couldn't get community corrections under subsection C if they weren't eligible for probation. The Supreme Court didn't squarely address this issue. You know, I think that the state in their brief talks about the Supreme Court approvingly referencing this line of cases. I think that's the strongest statement you can make about what they did in Grindstaff. Really, that provision of the opinion is dicta. I don't think that they squarely held it, and I don't think that it's fair to say that they have addressed this issue and held that this rule is correct. Going back to Staten's discussion of the waiver of fitness for probation, I would respectfully argue that there is no waiver of fitness in subsection C. There's only a waiver of the requirements of subsection A, the minimum eligibility requirements. One issue with the Staten opinion is that it conflates the terms fit and eligible. If you look those terms up in Webster's, Webster's defines the adjective fit as being synonymous with proper or suitable. Eligible is synonymous with qualified. And those are, I think, maybe related but different, distinct concepts. One thing I think that's useful to look at here is that subsection C's use of the adverb usually suggests that the term that it modifies, unfit, doesn't refer to the statutory criteria for probation eligibility. When certain defendants are eligible for a given sentence or ineligible for a sentence, they'll always be eligible. They will categorically be eligible. You wouldn't say that they are usually considered ineligible for that sentence. For example, you can't get the death penalty for DUI. We would never say that DUI defendants are usually considered ineligible for the death penalty. They're just not eligible for it. The Tennessee Supreme Court has held that legislative intent and purpose is to be ascertained primarily from the natural and ordinary meaning of the language used, without a forced or subtle construction that would limit or extend the meaning of the language. The Statton Rule is, I think, a great example of that kind of forced or subtle construction of a statute that courts are not supposed to engage in. I think one relevant consideration for the court is the canon of exclusio unis est exclusio alterius. I'm not sure if I'm pronouncing that correctly, but the negative implication clause, where the legislature includes particular language in one section of a statute but omits it in another section of the same act, it is generally presumed that the legislature acted purposefully in the subject included or excluded. Like I was saying, at the time that the Community Corrections Act was adopted, you had the Sentencing Reform Act of 1982, which specifically set a maximum probation length for probation sentences. If the legislature, when they adopted the Community Corrections Act, had intended to set a maximum sentence length, they would have either referred explicitly to the probation eligibility statute or put that language explicitly in the Community Corrections statute the same way they had with probation. The Statton opinion also talks about the ambiguity of subsection C. There's a provision in the opinion saying the language in this provision is obviously difficult. My position is that the statutory language here is not particularly ambiguous, but to the degree that it is, the rule of lenity would apply, and the statute should be interpreted in the light most favorable to the defendant, which would mean that under these circumstances, Mr. Murray is eligible for community corrections under the special needs exception. I know that this is an old rule that this court has reaffirmed many times, but just because an error is old and has been repeated doesn't mean that it shouldn't be corrected. I'm asking the court to take the opportunity to reverse that line of cases. Another rule that this court has created for special needs participants in the community corrections program is the requirement that a defendant's special need, either addiction or mental illness, be reasonably related to the offense itself. That is a requirement that, as far as I can tell, was first imposed by this court in State v. Boston in 1996, with no sort of reasoning or discussion whatsoever. It's just asserted in a litany of requirements for special needs consideration, and then is cited and repeated over and over again in multiple cases following that. That requirement truly has no basis in the text of the statute. It's just a court-created rule. And I think that in the same way as the Statton requirement, should be abandoned because it has no basis in the text of the statute, which is it's the fundamental rule of statutory analysis. Another way in which the trial court erred in this case is by failing to apply two relevant mitigating factors. One is factor 3 from 4035-115, that substantial grounds exist tending to excuse or justify the defendant's criminal conduct, though failing to establish a defense. The record here clearly establishes that Mr. Murray acted in self-defense when he shot Mr. Bonds after Mr. Bonds fired 3 rounds in the course of an attempted robbery. That was never disputed by the state. In fact, that was the reason that the state dismissed Mr. Murray's first-degree murder charge. Detective Christopher Stevick, who did an extremely thorough investigation in this case, testified at length at a bond hearing in July of 2021 about the circumstances of the homicide case. And it was very clear from his testimony that Mr. Murray had acted in justifiable self-defense at the time of the shooting. If Mr. Murray had been apprehended immediately following the shooting, then the justification of self-defense would apply not only to the homicide charge, but also to the felon in possession of a weapon count under 39-17-13-22. And because 7 months passed between the time of the shooting and the time that Mr. Murray was found in possession of the gun, Arguably that defense didn't apply anymore. But the bottom line is that the fact that Mr. Murray had this gun may be the reason that he's still alive. It was something that he used in self-defense, and that means that factor 3 applied and should have been applied by the trial court. It wasn't. Another factor that the trial court should have applied here was the catch-all factor, factor 13, because of the extreme racial disparity in felon in possession prosecutions in Davidson County. I submitted a report from the Metro Nashville Office of Criminal Justice Planning prior to the sentencing hearing in this case. That report contains statistical information about the racial makeup of defendants charged with felon in possession in Davidson County and state court. And it showed that in 2021, 85.5% of defendants charged in general sessions court, charged by arrest warrant, were black. 82% of defendants indicted and prosecuted in criminal court with this offense were black, and Mr. Murray was part of that 82%. According to the 2020 census, black people made up 27.4% of Davidson County residents. They make up nearly everybody charged with this specific offense. Sentencing is an area where I think common sense notions of fairness are paramount, and factor 13 is a tool that courts can use to consider those kinds of fairness considerations, even if they aren't specifically enumerated in the mitigation statute. 4035
studies on the percentage of, say, violent crimes.
I'm sorry?
The percentage of violent crimes that were charged by one particular race or another. Did you do that? You got the total population, and you have this offense. In between is that.
The only data that I've presented is about felon in possession prosecutions. But 4035-1022 provides that the Sentencing Act is designed to eliminate unjustified disparity in sentencing. And I think that when you are essentially prosecuting only members of a single racial group for a particular offense, that's the epitome of an unjustified disparity in sentencing. This is, I think, a manifest injustice that the court should have considered in applying factor 13. The second main issue that I've raised is that the court erred in imposing a consecutive sentence in this matter. I think this issue requires, a close reading of the transcript of the hearing where the trial court ultimately rendered its judgment. The sum total of the court's explanation of its decision to impose a consecutive sentence was that, the court said, and this is going to be consecutive to his other case. There was no discussion of the multiple conviction statute. One, I think, particularly troubling detail here is that earlier on in the hearing, the court made a statement that suggested that the court believed that consecutive sentencing was mandatory here. Now, if you look specifically at volume 4, page 55, line 6 of the record, the court stated that Mr. Murray's sentence in this case was automatically consecutive to the probation violation. I explained why that wasn't true and discussed Rule 32 of the Rules of Criminal Procedure. The court never corrected itself. And I think the fact that there was ultimately no discussion of the basis for the court exercising its discretion to impose a consecutive sentence suggests that the court may well have been confused about the discretionary nature of this decision. In State v. Pitts, a case this court issued last month, the court reversed a sentencing order and remanded the case back for a second sentencing hearing on basically the same grounds as this. That involved a dispute over the manner of service as opposed to consecutive sentencing, but it was a situation where the record was full of horrible facts. There was more than enough there for the trial court to have imposed a sentence to serve, but because they hadn't made the relevant statutory considerations on the record, this court vacated that order, sent it back for a second sentencing hearing. The one issue with the consecutive sentencing order is that not only did the court fail to articulate why it was imposing a consecutive sentence and what relevant hook from the multiple conviction statute it was relying on, but it failed to engage in any kind of discussion of whether or not the aggregate resulting sentence was justly deserved in relation to the seriousness of the offense and no greater than deserved for the offense committed. The Tennessee Supreme Court has held that 1021 and 103.2 apply to consecutive sentencing. They held that in the Imfeld decision. And so we are asking that the court modify Mr. Murray's sentence to community corrections. If you find that he is not eligible for community corrections, that you at least modify the sentence so that it is running concurrently with the prior sentence, or at minimum, remand this case back for a sentencing hearing to determine whether or not a consecutive sentence should have been imposed. Thank you.
All right. Thank you, sir. Good afternoon, General.
Good afternoon, Your Honor. May it please the court, Ben Ball on behalf of the state. Here, the trial court properly denied the defendant a sentence of community corrections because the defendant was not eligible for that, because he was not eligible for probation. And 30 years of published controlling authority tell us that. Published cases from this court and Grindstaff discusses these cases. Very briefly, but it does state in Grindstaff that a person who's under the special needs provision who is not eligible for probation is not eligible for community correction. That is the law. The defendant certainly can challenge that at the next step, but this court is bound by it.
But the defendant seems to argue that because that wasn't on all fours in Grindstaff, that it was a post-conviction. Does that change the fact that the Supreme Court referenced it the way it does?
It does not. The Supreme Court states it.
We're still bound by Grindstaff.
You were bound by Grindstaff. I will acknowledge there's not a thorough analysis of this line of cases, Staten or Staten, however you pronounce it, but it is that is asserted, and there is a line of cases published from this court, and so the Staten analysis is the law, and this court should stand by it. As for consecutive sentencing, up front, I can acknowledge that these are not the cleanest findings. The way I look at it, there often we see two types of findings. Both may be acceptable. I'm a big fan of I'm going to do sort of the subsections of the brief type analysis. Let's talk about, alternative sentencing. Let's talk about talk about the length of this. This is not what this trial court did. The trial court did here is what I would call the grab bag. Essentially make a lot of findings and then pronounce the sentence. While it may not be preferable, it is still effective. And here, in making those findings, the trial court noted that the defendant was on probation at the time of the commission of the offense. That supports the imposition of the consecutive sentence, and even if this court were to look at it de novo, it would support the imposition of a consecutive sentence. So if this court has no further questions, I would urge this court to affirm the trial court on all these grounds.
Let me just,
Go ahead. You go ahead.
that last statement, you're saying that he's on probation, so that's grounds for consecutive sentence. You're not arguing that's mandatory, right?
No, it is not mandatory, but the trial court, when it gets to the findings portion, when the hearing is over, when they're done putting on proof and they're done arguing, and the trial court makes its findings, right smack dab in the middle of those findings, it makes a point of saying the defendant was on probation at the time. That is a factor that bears on consecutive sentencing, and it justifies the imposition of consecutive sentencing here. For that reason, the trial court did not.
Is it not also a factor that would affect the length and manner of service?
Certainly, and that's not uncommon. We saw it here with my esteemed colleague talking about enhancement factors, because we can consider enhancement factors for purposes of alternative sentencing. That's not what's keeping this defendant from getting alternative sentencing. He's simply not eligible.
If I understand what the defendant's position is on the consecutive versus concurrent, the record in front of us is going to be one of two things. Either there's no specific findings as to why she ran the sentences consecutively, and I'll get back to yours in a second. There's nothing there that we can say definitively, this is how she analyzed it and this is why she ran them consecutively. Or she may have run them consecutively because she thought it was mandatory, because that was what she said initially. She was hopefully very diplomatically and professionally corrected by the attorney for the defendant, but apparently she never said, "Thank you, attorney, I stand corrected." So So it could just be, yeah, I think they're mandatorily consecutive sentences. That's, it's my understanding, that's what he said, defense counsel says is the record we're looking at. Now, what you're saying is, because during her findings, I say her, I think it's Judge Blackburn, during her findings, she did mention a factor that could justify consecutive sentencing. So the reason you call it a grab bag theory is because we can grab that out of the bag and assume that that's why she ran them consecutively. I'm not saying that's not proper. I'm just asking if that's what your theory is.
I didn't call it the grab bag to suggest that it sort of lessens the burden in any way. What I mean by that is what we often see trial courts sort of make all their factual findings up front that affect the sentence and then just pronounce the sentence, when perhaps the more organized way might be to say, now I'm talking about the length of the sentence, here are the enhancement, but sometimes they also just say, here are my findings about these many factors. And that's essentially what happened here. I can tell you it makes it harder to read through, but it doesn't make it improper.
Well, I totally understand what you're saying, I think, because two of us have been trial judges, and I know I probably, in sentencing, probably more times than I should have, I probably just, like I'm doing right now, rambled on and on about what factors I found to be present. And I may not have circled back around to tie them in I also prefer now, as an appellate judge, the more organized fashion that you have alluded to and promoted.
It's not something that would be innate to me. I'm not the most organized person, but I have found that it is preferable. But I want to be clear about these also where these sort of two parts of the record are. The exchange that my esteemed colleague referenced essentially happens in sort of I believe the mid-50s of the transcript during the argument portion, and no doubt that there is a statement that the trial court makes that is not accurate and is quickly corrected, but these are not findings there.
Well, last and probably least, or not least, if we do have a record, as defense counsel has pointed out, your position would be, even if we said, well, we're going to review this de novo, we would be able to see from the record a valid reason to run the sentences consecutively.
That would be
based on
position.
her findings, however organized or not they might be, right?
That is the state's position, but primarily your position would be that you wouldn't need to get to de novo review to affirm this. You can say that there is no abuse of discretion here.
All right, thank you, General.
Thank you, Your Honor. If no further questions, I ask this court to affirm.
Thank you, sir. Rebuttal time, I think 5 minutes.
Yes, thank you. Let me just ask the court to go and take a close look at the record in this case. And from my perspective, there are two key portions. If you look at all these transcripts, it's volume 4. Page 55 is where the trial court claimed that the sentence in this case was automatically consecutive to Mr. Murray's probation violation, to his sentence in a prior case. And then if you look at, I believe it's page 63, the second to last page of the transcripts, that is where the court renders its judgment and articulates the basis for the sentence. The only discussion at that point of why there is no discussion of why she's imposing a consecutive sentence. She just announces that the sentence will be consecutive. It's true that earlier in the proceedings, she had made a finding of fact that Mr. Murray was on probation at the time of the offense. I acknowledge then, I acknowledge now that under 4035 115B6, that gave her the discretionary authority to impose a consecutive sentence, but it was discretionary, it wasn't mandatory. I think that there's a difference between making a finding of fact that could serve as a basis for imposing a sentence and actually making the findings that this court and the Tennessee Supreme Court require trial judges to make. There's no requirement that a trial judge, you put magic words on the record when they're rendering a decision like this, but they have to articulate the basis for the judgment. They have to articulate it in terms of the principles of sentencing, the purposes of sentencing, the factors laid out in 4035 210B, and there was none of that here. And so it's not just a question of whether or not she identified the specific hook under 115. There was no discussion of whether or not the aggregate sentence of 20 years was appropriate in this case. And so you have the authority under 4035 401 C2 to modify the sentence. And if you do nothing else, I would ask that you modify the sentence so that it is concurrent with the pre-existing sentence. And I think the primary reason for you to do that is that ultimately this is a case where Mr. Murray used a gun in self-defense, may have saved his own life, and this led to him getting a sentence of 15 years to serve in prison, run consecutively to a different sentence. I just think that on these facts, which were not contested by the state in front of the trial court, laid out by the state's own witness, by Detective Stevick, who had done an extraordinarily thorough investigation of the homicide case, I think that in and of itself weighs in favor of a lesser sentence that you can achieve by running this concurrently with the earlier sentence. If there are no further questions, that's my argument. Thank you.
All right, thank you, Mr. Allensworth. Your brief was a very well-written, excellent brief, so we appreciate that. So was yours, General, but his was a little longer because he had a lot more things to discuss. But short is good.
Yours would have been real short, like
Yeah, brevity.
earlier today.
We do like brevity, but we also like well-reasoned and briefs like we got in this case. So